Good afternoon, ladies and gentlemen. I warmly welcome you all to the third session of the second day at the 13th International Research Conference of General Sir John Kotelawala Defence University. Presently, you are here with us in the technical session held under the theme of Contemporary Challenges and the Role of Private Law. This time, KDU International Research Conference is held in a different platform due to the current pandemic situation of the country. Therefore, this session will conduct in a virtual platform. The session will be chaired by Dr. Dan Gunasekara. Ladies and gentlemen, we have the honor of giving a brief introduction of the chairperson of this session. Mr. Gunasekara passed examinations of the Incorporated Council of Legal Education from 1993 to 1995 at Sri Lanka Law College, Colombo, and called into the bar in December 1996. He obtained Masters of Law in International Law with honours cum laude from University of Utrecht, the Netherlands in 2001, and Doctor of Philosophy in International Commercial Maritime Law between 2002-2005 with honours cum laude from University of Hamburg. He received a scholarship from International Max Planck Research School for Maritime Affairs, Hamburg, Germany from 2002 to 2005 to complete his PhD studies. Currently, he renders his services in diverse disciplines such as Senior Visiting Lecturer, Faculty of Management, Humanities and Social Sciences at Colombo Nautical and Engineering College, Campus Malawi, Sri Lanka. Senior Visiting Lecturer, Department of Economics, Faculty of Arts, University of Colombo. Faculty of Law, Dalian Maritime University, China. Visiting Lecturer, Senior Visiting Lecturer for University of Bedfordshire, UK, in its LLB degree program connected at Sinek campus. University of Staffordshire, UK, in its LLB program conducted at Api, Sri Lanka. And University of New Buckinghamshire, UK, in its LLB degree program conducted at IDM Nations Campus, Sri Lanka. Now, I cordially invite Dr. Dan Gunasekara, the chair, to commence the session. Over to you, sir.
Thank you very much. Before we commence our presentations, I would like to give some instructions where the candidates are required to note that you're expected to introduce your topic, and then your time of presentation is limited to 10 minutes to each presenter. And after the candidate finishes the presentation, the audience is open for questions as a common session, and there will be 20 minutes time period that is allocated for the questions and answer sessions. At the end of the session, I will be summing up the presentations by the authors and giving a feedback. So with that, or those remarks, I would like to commence the session on contemporary challenges and the role of private law. And I'm happy to have Ms. B.K. M. Jayasekara with me as the rapporteur for this session. And today we are having 4 authors presenting their piece of work. And firstly, I would like to invite the authors N.K. Delige and A.A. Edri Singha, who will be presenting on work from home, or now what we are really conversant with, the WFM, the legal status of Sri Lanka. And let me give a brief introduction about the author, or rather the authors. The authors are senior lecturers in the Faculty of Law, General Sir John Kotelawala Defence University, Kotelawala, and are attorneys at law. Authors hold LLB honours from the Faculty of Law, University of Colombo. Ms. N.K.K. Mudalige holds LLM from General Sir John Kotelawala Defence University and Master in Labor Relations and Human Resource Management from University of Colombo. Her research areas are environment protection, labor rights, and rights of differently abled people. Ms. A. Edirisinghe, on the other hand, holds an MPhil from University of Colombo and LLM from Ealing University, or Law School rather, University of West London, United Kingdom. And her research areas are environmental law and animal rights. So now I open the floor for N.K.K. Mudalige and A. Edirisinghe, who will be presenting on the topic work from home, the legal status of Sri Lanka. Over to you.
The title of my presentation is Work from Home, the Legal Status of Sri Lanka. This presentation is based on a research paper co-authored by myself and Ms. N.K.K. Mudalige. This is the outline of my presentation. First of all, I will give you a brief introduction to our research. Work from home, or WFH in abbreviation, is not a novel concept theoretically. However, the practical application of work from home did not impact on many types of employment in the world until the COVID-19 situation. The recent COVID-19 pandemic compelled the employees around the world to work from their own home without attending their usual place of work. The law on work from home, however, was silent in many jurisdictions, and Sri Lanka is no exception to this general rule. In the meantime, the requirement of proper guidelines with regard to work from home popped up due to unfairness and unbalanced experiences faced by the actors in the contract of employment. And who are these actors of the contract of employment? They are the employer, employee, and the state. In this context, the research problem that we sought to address is whether the legal status of Sri Lanka with regard to work from home condition is adequate enough to protect the interest of both the employer and the employee. The research was carried out using three methodological approaches: Blackletter approach of research and the comparative and international research methodology based on legislative enactments and international legal standards as primary sources, books, journal articles, conference proceedings, theses, and online resources as secondary sources. Empirical research methodology was used as the third methodology to examine the law in the context as opposed to the law in the text. The empirical research methodology was carried out through observations made by the two researchers. Now I will move on towards the discussion and analysis part of our research. The work from home concept creates number of issues when it comes to the rules or the laws governing usual employee-employee relationship. The first one arises with regard to the control. The usual contract of employment sometimes is not compatible with the needs of the work from home. According to the common law theories introduced by the cases Regina versus Walker, Ready Mix Concrete Limited versus Minister of Pensions and National Insurance, the element of control and other related facts can be considered in ascertaining the contract of employment. However, These traditional theories or the conventional theories are not suitable in a work from home situation. However, still the control of the right to control should be established by the employer in the work from home situation in order to continue the contract of employment instead of actual control. Therefore, work from home guidelines should include a mechanism to provide the authority to the employer to maintain the right to control the employee for a certain extent. The second issue arises with regard to the default place of work. Usually it is required to expressly mention about the default place of work of the employee, which can be understood as the place or the location where the work would typically be expected to carry out. However, in the case of work from home, the default place of work will be different because fundamentally the employee is working from his own home. However, in order to maintain the same contract of employment with the same level of control, it should be mentioned home of the employee as the alternative place of work during work from home. The third issue arises with regard to hours of work. How to calculate the hours of work during work from home situation. In Sri Lanka, for private sector employees who are covered under the Shop and Office Employees Regulation of Employment and Remuneration Act number 19 of 1954, the maximum hours of work is stipulated as 8 hours according to section 3(1) of the Act. However, there is no practical way of calculating the hours of work of an employee in a work from home situation. Therefore, this conventional requirement of hours of work should be dispensed with in a work from home situation. Instead, there can be other alternative methods adopted, for example, the deadline system. A deadline system will protect both the employer and the employee. In this mechanism, a particular task will be assigned to the employee with all the responsibilities and clear instructions, and the provision of these responsibilities and instructions will be the duty of the employer. And the employee is expected to carry out these duties assigned to him by the employer within a given time framework. Technology can be used as a tool to communicate in this regard. However, the law can prescribe a minimum hours of work to selected employments. And what are these selected employments? For example, administration or clerical works. In those type of situations, hours of work can be calculated using technology. According to Harvard Business Review, there can be several challenges in self-management under work from home condition. Therefore, the understanding of the situation should be mutual between both the employer and the employee. Otherwise, it may trigger industrial disputes due to the unsatisfied workforce in the country. The next issue is work-related costs. There are certain costs of operation, functioning, maintenance and repair of equipment which are usually borne by the employer. Now, in the work from home condition, it is kind of skeptical who has to bear these work-related costs. According to International Labour Organization's Home Work Recommendation of 1996, it is required to keep records of the employees who are working from home, time allocated, rate of remuneration, costs incurred, deductions of remuneration if any by the employer. The administration would be effective in such record keeping according to the international standards. And in the work from home situation, the employer is expected to bear all these work related costs which are properly recorded in his records. Then the The next issue arises with regard to industrial disputes. During work from home condition, there should be a proper mechanism to prevent, settle and investigate industrial disputes. The state should be vigilant on this regard, since both the employer and the employee are under a lot of pressure from challenges in the employment. Industrial Dispute Act number 43 of 1950 should be amended accordingly to cater such needs of the employer and the employee. The next issue is with regard to remuneration. It is prohibited that the application of work from home implies a reduction in the rights of the worker, especially in their remuneration. However, when the work from home situation occurred due to a pandemic situation, the employer might also be in trouble in terms of income. Therefore, the employer may also need a relief in terms of payment of remuneration, wages and salaries to the employee. According to ILO's homework recommendation, it can be regularized a minimum wage to be paid to employees, or if the situation permits, the minimum wage must be a result of collective bargaining and mutual understanding. The next issue arises with the types of employment which cannot be functioned through work from home. Not every employment can be carried out from home. So work from home concept is not suitable to all the types of employment. There should be a proper mechanism to manage these industries which are not capable of being carried out from the home. Both the employer and the employee are not in a position to perform and to serve or produce if the situation doesn't support to work at the default place of work. Such industries include for example, hotel, plantation and manufacturing, etc. Finally, it is a finding that the employee's duty of care to check on the worker should be established through proper legal guideline apart from the above analyzed factors. Now I will move on towards the conclusion and recommendation. From the findings of our research, we have laid down certain recommendations which shall be adopted. The first one is default place of work and the alternative place of work should be defined within the contract of employment when it comes to work from home. The second one is parameters of work from home arrangements and performance objectives and expectations should be clear and discussed on a regular basis. Third one, hours of work and the right to disconnection should be clear. Otherwise, the employee will have to work 24/7 without having the ability to disconnect from his work. The next one is facilities provided by the employer should be clearly communicated and the cost should be borne by the employer, not the employee. Fifth one, the employer should have the duty of care towards the health and safety, welfare and other related aspects. The final one, remuneration should be expressly agreed upon by the both parties. That means the employee and the employer. With that, I finish my presentation. Thank you very much.
Thank you very much. For the presentation, we discussed about various different angles of the topic that the researchers have selected. So I think now it's time to open up the floor for questions and answers.
propose work from home as a temporary measure for the emergency period or as a permanent form of performance of work from home?
Actually, we have suggested this mechanism as a contemporary measurement, but also at the same time we prefer that we suggest that this mechanism be in effect throughout this whole process when we need it in an emergency time.
From researchers, both researchers, I would like to ascertain that do you propose law reform in this area in the general body of labor law, industrial law in this country, or do you have any specific points that you want to make or included into the into different specific statutes? And also, as you might also think that Sri Lanka and other countries are facing the new normal, and new normal has created new norms, and this is a new work norm, and it's very good that very commendable research that you have undertaken. But I would, at the same time, in all likelihood, this new normal would stay for a while, as per the WTO World Health Organization forecast. This will go down the line for at least 3 more years until we find the any light in the tunnel. So, do you see that this new normal to be conceptualized into the legal specific legal statutes in this country?
Actually, we actually recommend that there should be a separate statute to encounter and address this work from home situation. And yes, and for other, when it comes to the existing statutes in terms of labor law, there should be a reference to the new statute with regard to the work from home situation.
So, overarching statute is the final word
Yes.
that you might think. Very good, and you can incorporate this, and this can be also communicated to the policymakers of this country. Thank you.
Thank you, sir.
Any other questions? Now, in the meantime, let me ask a question from the chair. Now, with regard to your work, I didn't see much of the attention that you have taken out of the regulations that were passed in Sri Lanka, especially the Employers Federation that involved during the COVID period, especially the lockdown period. We saw that there were various concerns raised by the Employers Federation of Ceylon, and sometimes the Department of Labour had to put out certain regulations that were to be implemented. And also, the other aspect is that the technological aspect, especially when it comes to the use of internet and other resources, what kind of the technological advancement need to be addressed in any of the related instruments of Industrial Dispute Act, or rather taking Industrial Dispute Act as the umbrella act and then have the other regulations and the acts coming under that. So my question is whether you have addressed these regulations that came up newly, as well as the technological development that we need to address in the forthcoming law.
Actually, in our
full paper, we have addressed the issue, we have addressed about the regulations to put forward by the government during the lockdown situation, but we have limited our research into this policy making with regard to work from home, and we haven't touched upon about this industrial dispute resolution. We are actually hoping to extend this research in a novel way with regard to that in the industrial dispute resolution in terms of this work from home situation in a separate research actually.
Any other questions? So if there are no questions, I will go to the second presentation. Let me first of all introduce the second presentation in this technical session. The title of the abstract is A Critique of Available Remedies for Industrial Disputes Arising Out of COVID-19, a Comparative Analysis. The authors are H.G.S. Rosaido and H.D. Jayavira. So if I may briefly state the bio of H.G.S. Rosaido. H.G.S. Rosaido is an undergraduate of the Faculty of Law of General Sir John Kotelawala Defence University of Malana, Sri Lanka. He is currently reading in his fourth academic year. His other interests include debating, mooting and sports. He has participated in the House Door debates in 2017 as well as the Victor's Moot 2018 and the national rounds of Henry Dunant Memorial Moot Court Competition 2019. His research areas include labor law, corporate law, tax law, international humanitarian law, as well as the law of the sea. And about H.D. Jayavira. H.D. Jayavira is an undergraduate of the Faculty of Law of General Sir John Kotelawala Defence University in Ratnamala, Sri Lanka. He is currently reading in his fourth academic year. He was Vishal Instrumental Violin degree from University of Lucknow, India. He also has achieved the preliminary certificate of Business English and Council of Europe level B1 achievements from University of Cambridge in 2013. He holds a diploma in accounting and business by the Association of Accounting Technicians of Sri Lanka AT and is a past finalist. He is also currently studying in the operational level and Chartered Institute of Management Accountants, CIMA, UK. His research areas include corporate law, constitutional law, administrative law, and labor law. So over to the next presenter.
Mr. Chair, my dear lecturers, fellow authors and participants. This paper was prepared by myself, H.G.S. Rosaido and Mr. H.D. Jayavira, and I will be presenting for today. Let me begin by stating that although COVID-19 began worldwide spread in Sri Lanka during 2019 for the whole world, in Sri Lanka the first wave began about in March 2020. Although now Sri Lanka is in the second wave, this work was conceived and prepared entirely during the first wave, and the issues presented and the research problem were relating to the context at that time. By this presentation, we expect to give a brief overview of the context of our work and the significance thereof, subjected to the time limitations. This work presents solutions to a pressing issue created in the social context in Sri Lanka, and it also presents ideal measures to be taken if issues of similar nature reoccur in the future in order to achieve optimal solutions. Since the confirmation of the first patient in Sri Lanka, there were to follow nearly two entire months of continuous curfew reopening of businesses only approximately mid-May. This has resulted in a variety of industrial disputes from workers being laid off due to restrictions in workforce, or in some cases simply due to businesses struggling financially. And therefore an issue was raised as to whether the existing methods of providing relief for industrial disputes have the capability of presenting the required just and equitable solutions to industrial disputes in this context. At this point in time addressed by this work, many employees were being laid off and even employees were struggling financially. And this created a large number of industrial disputes at the same time. On the other hand, it's notable that due to the sensitive nature of industrial disputes, favorization is shown for ADR methods, since it is generally accepted that alternative dispute resolution is in fact superior due to the use of just and equitable principles more so than in the ordinary course of the land. Although the preference for ADR methods in the resolution of industry, the context of this work created an issue wherein the use of ADR methods was no longer the practicable approach for the resolution of industrial disputes. The reason for this is that due to the nationwide occurrence of many simultaneous industrial disputes, there was in fact a sudden surge of industrial disputes. And while the number of industrial disputes were rapidly on the rise, there was no corresponding increase of ADR facilities to hear such matters. If I may give an example, the number of mediators required for additional mediation boards was not increasing. Therefore, the only option would be to hear industrial disputes and give determinations and awards at a rapid pace. And this in turn may cause miscarriages of justice and would change the status quo. And this may result in a deviation of ADR methods from just and equitable principles. On the other hand, the Industrial Disputes Act No. 43 of 1950 provides for a party aggrieved by a decision given by ADR methods to pursue ordinary litigation. However, due to the increase of the number of aggrieved parties at a rapid rate, the number of parties approaching ordinary courts would also be increasing comparatively. And even though such parties file actions in ordinary courts, their likelihood of achieving a just and equitable remedy for their industrial dispute is once again somewhat narrow. And furthermore, this situation also creates an overcrowding of cases in both the ordinary courts as well as ADR methods. And this is the gravity of the requisite context in respect of industrial disputes. Therefore, in this situation where justice and equity for industrial disputes is not assured by the established legal means in the said context, this work explores possible alternative methods for the achievement of justice and equity for industrial disputes rather than the already available methods. And this work presents the opinion that enacting a new legislation for the resolution of industrial disputes is the best method, since the Industrial Dispute Act is incapable of facilitating the resolution of industrial disputes upholding the ideal of justice and equity in this context. However, the context is once again posing an obstacle in that the enactment of a legislation with the ordinary method was not practicable due to the situation of the country at the time. Therefore, there are in fact two contextual situations which stimulated our work. The first contextual issue is the potential industrial disputes arising out of unforeseeable circumstances created by COVID-19, which gave birth to the main issue of the incapability of the Industrial Disputes Act to give just and equitable remedies to the aforesaid industrial disputes. And as aforesaid, this work attempts to present a solution for this incapability of the Industrial Disputes Act, and namely the enacting of a legislation to uphold just and equitable principles in industrial disputes. However, there is once again an obstacle to passing a new ordinary legislation to the Parliament, and the situation is that in this time period it made it impossible due to the Parliament being unable to pass legislation in order to resolve industrial disputes in a manner which upholds just and equitable principles due to the dormant nature of the Parliament. The presence of the dormant nature of the Parliament is in that time period is what we recognize as the second contextual issue of this work. The reason for the dormant nature of the Parliament is that the Parliament lacked the authority to pass legislation at that time period. This is due to the fact that this time period was one between the appointment of the newly elected parliament, which had taken place just prior to the COVID-19 outbreak in Sri Lanka, after which the general election was to be conducted. However, due to the restrictions posed by the precautionary measures against COVID-19, the state was unable to conduct a general election at that time, which in turn caused the inability to summon the parliament at the time. Therefore, it can be said that the state had a president but no parliament. Therefore, in the absence of a parliament, a legislation upholding just and equitable principles could not be passed at that time. And this is why what the authors interpret as a dormant parliament, and that is the second contextual issue of this work. Therefore, technically speaking, we will say that the dormancy of the parliament arose once again out of the COVID-19 outbreak in Sri Lanka. And therefore, the first and second contextual issues are inextricably interconnected and interlinked together. The clarification of the context and the issue of this work is now complete, and in simple terms, as the surge of potential industrial disputes caused by unforeseeable circumstances arising out of COVID-19 renders the existing ADR methods provided by the Industrial Disputes Act as well as the Ordinary Code incapable of upholding just and equitable principles at that time. In order to satisfy the need to uphold justice and equity, this work assessed the option of enacting a substitute legislation in place of the Failed Industrial Disputes Act in that context to safeguard the application of just and equitable principles in industrial disputes. However, it became clear that this option is once again unavailable. Therefore, this work was supposed to investigate as to whether any other avenues are available for resolving industrial disputes while upholding just and equitable remedies in industrial disputes. The result of this investigation is that under the Public Security Ordinance number 25 of 1947, the President is vested with the power to enact legislation without reliance upon the Parliament. While the employment of the above power under the Public Security Ordinance is only available during an emergency situation, such a situation was indeed prevalent at the time of this work. And the Public Security Ordinance provides many instances in which the President is vested with the above power, and we selected a few that are relevant to this work, and those are that we perceive such an enactment necessary or expedient in the interest of public security and the preservation of public order in the community, as well as the maintenance of supplies essential to the life of the community. It is also notable that such an enactment cannot be challenged in the courts of law. In conclusion, this work identified that the aforesaid power given to the President via the Public Security Ordinance indeed enables for the swift enactment of legislation, which is especially required in a situation where the Parliament is dormant. And therefore, the President has the power to enact legislation upon pressing concerns arising due to COVID-19 situation relating to industrial disputes, with the flexibility and versatility required for just and equitable redress for the present issue, especially in a situation where the power of the Parliament was problematic at that time. And it's notable that this work does not restrict the application of the aforesaid recommendation purely to the COVID-19 context. Rather, this finding may be employed successfully in many unforeseeable future situations where firstly the swift enactment of legislation is required, and secondly the Parliament is temporarily incapacitated in an emergency situation where the emergency situation is in fact the cause for the dormancy of the Parliament. And that brings our presentation to an end.
Thank you very much.
Thanks.
So the audience is now open for questions.
Okay, one issue you mentioned is that there are a lot of cases coming up, and there are no enough resources to hear those cases. So even if you propose separate enactment, judicial legislative enactment to resolve that case, what kind of alternative judicial proceedings would you suggest to resolve that problem?
Thank you for the questions. And what we recommended in our work is more that the existing judicial proceedings be expanded in order to hear and determine more cases in the same time period. For example, we would recommend the ability to hear multiple cases of similar facts and similar issues together in order to give a quick remedy, a quick resolution to the industrial dispute that also upholds the justice and equity required in the sensitive nature of industrial disputes. I hope I answered the question sufficiently.
My question is, at present, what we have is the adversarial system of litigation, even in labor tribunals. It is a form of adversarial system. But in an emergency like this COVID situation, I believe that even the method of litigation should be an inquisitorial system rather than adversarial. What do you think about this suggestion?
Sir, thank you for the question. And in direct reference to your question, if we were to suddenly, there are different benefits in terms of the expediency and the for the more accurate upholding of justice and equity in terms of an inquisitorial system rather than an adversarial system. And that is true. However, I would also like to point out that it may not be the ideal time to suddenly bring about a complete upheaval and sort of a reversal of the general system of trial from an adversarial system suddenly into an inquisitorial system. So it has both pros and cons of your recommendations, in my opinion. And I hope.
Yeah, let me put a question from the chair. Now, since you address the alternate dispute settlement or resolution process, the ADR here, we have seen during the COVID period that in countries like United Kingdom and United States, they changed they rather adopted certain procedural rules for online dispute settlement process. Have you ever, in your research, addressed the online dispute settlement process as a kind of a support element to the ADR system? Because it can be readily applied in the industrial dispute area, but only thing is that we need to get or bring in the statutory statutory changes. Yeah.
Sir, can you repeat the question just once more for me?
Yeah, my question was whether in your research you have addressed about adapting certain online dispute settlement means as a supporting element to the ADR system that you propose.
So I would like to admit that we did not, in fact, go for such procedural recommendations, and we simply limited our research to a doctrinal research paper. However, I would like to say that your recommendation definitely has value, and we do have lessons to learn from other countries and in how they adapted to the situation of COVID-19. And I would like to go further to recommend that in addition to our recommendations, what you state is also definitely a very valid recommendation, and it should be considered. And in our further work, we would like to sort of expand and take in your comment into consideration as well.
Thank you. So, are there any other questions from the audience? Thank you very much, and I will now go to the third presentation for the technical session now. And the third presentation is titled Employment Security of Probationary Workers in Sri Lanka, a Comparative Legal Analysis. Author is Barwantika Aryaratna. To tell about Barwantika Aryaratna, she is an attorney at law and a lecturer in law attached to the Department of Legal Studies, the Open University of Sri Lanka. She holds LLB degree in Faculty of Law, University of Colombo, and LLM with a merit pass in the same university. Currently, she is teaching labor law for the LLB students and doing several researches in relation to the various aspects of labor law. So, over to you, Vartika, for your presentation.
Thank you very much for your introduction, sir. I hope you all can hear me. I'm Rohantika Aryaratna from Department of Legal Studies, Open University. Can you hear me?
Yes, we can hear you.
Right, okay, thank you. My topic is Employment Security of the Probationary Workers in Sri Lanka, a comparative legal analysis. Before start my presentation, I would like to give you a roadmap to my presentation. I'll start with the background to my research, then research problem, objectives, methodology, results and discussion, finally conclusion and recommendation. So let's start with the background with my presentation. We know the employee-employee relationship is based on the contract of employment. A contract of employment reflects the rights, duties and liabilities of the employer as well as the employee. So based on the nature and terms of the condition of the contract, we can categorize contract of employment into different types of employment. So these categories or labels may have significant consequences on employee rights and benefits as well as the security of the employment. When it comes to the probationary employment, probationary employment is one of the challenging employment types which indicates some kind of uncertain nature of job status in the labor relations. Actually, we know the employment security is important to maintain efficient and satisfactory working environment. So, there is some kind of issue in probationary employment with regard to the security of the probationary employment. So, this background leads me to my research problem. As I mentioned, the probationary employment indicates some kind of uncertain nature. So, why this kind of uncertain nature indicating probationary employment? The reason is probationary period is considered as a trial period, and therefore it raises question whether the employer has unlimited discretion to keep or dismiss a probationer. So when we look at the Sri Lankan context, we can find a long series of cases which answer this question in different manners. So in my research, I investigate the problem of employment security of the probationary workers in Sri Lankan legal framework. Then I move to my research objectives. As you can see, my first objective is to analyze the existing legal provisions and decided cases in relating to the employment security of the probationary workers in Sri Lanka. Then, I would like to compare and contrast the existing Sri Lankan law with South African legal framework. And finally, I would like to suggest possible recommendations to enhance employment security of the probationary workers in Sri Lanka. Then I move to my research methodology. As you can see, actually my research is qualitative legal research. A qualitative legal research could be a doctrinal, theoretical, problem-based or reform-oriented research. So my research is a reform-oriented legal research, so I use comparative legal research method in order to propose recommendations or the reforms to the Sri Lankan legal system. When it comes to the data collection and data analysis, I use text review or the literature review approach as the main data collection technique. So I analyze both primary and secondary legal sources. As primary sources, case law and legislation of both these two jurisdictions. In my comparative study, I used South Africa as a comparative jurisdiction. So I analyzed both case law exploring both South Africa and Sri Lanka as primary sources. As secondary legal sources, I analyzed textbooks and journal articles and other research papers. Then I'm moving forward. Result and discussion. Before moving to the Sri Lankan legal framework, I would like to briefly explain few definitions of the term probation. Actually, this still defines that the probation is a for which an organization employs a new employee in order to assess his attitudes, abilities and characteristics and the amount of interest he shows in his job. Similarly, in State Distilleries Corporation vs. Rupasinghe case, Justice Fernando emphasized that the concept of probation is a period of trial at the end of which the employer must judge the performance of the probationer. So, these definitions in generally provides that the period of probation is fixed and limited period of time which subjected to the supervision of the employer. So, then we come to the Sri Lankan legal approach on the employment security of the probationary worker. Actually, I would like to highlight one important thing. In Sri Lankan context, there is no legislative provision or guideline for regulating the status of probationary employment. So also, when we look at the duration of probationary period, there is no clear provision in our labor law with regard to the duration of probationary period. And the Employment Fairness Number 8 of 1978 Act provides that employers and workers may enter a contract of training for up to maximum 1 year. But this provision is not directly relevant for the probationary employment. So, due to the lack of legislative provision, we have to look at the judicial interpretation to identify the Sri Lankan legal approach. As we discussed earlier, probationary period is a kind of trial period. So the purpose of this trial is to assess the capacity and capabilities of probation. But the contentious issue is whether a probational service could be terminated before the expiry of probationary period. So the termination of probationers is one of the controversial and important topics with regard to the employment security of the probationary workers. With regard to this matter, it is evident that our court has put forward a traditional view through a long series of cases. Here you can see, here I have mentioned some of the cases. As you can see, Musashi Limited versus Rasaya, this case put forward a traditional viewpoint. In this case, the court emphasized that the employer is the sole judge to decide whether the services of a probationer are satisfactory or not. The employee is not found to show good cause where he terminates the services of a probationer at the end of the term of probation or even before the expiry of that period. So it means the employer can terminate the probationer during the probationary period before expiry of his probation. And similarly, Richard Peary's case, Ceylon Ceramic Corporation case, and also the University of Sri Lanka versus DBK case and several other cases, court re-emphasized this traditional view. So, accordingly, it can be observed that the court considers that the probationer is almost at the mercy of his employer and he has no remedy where he is terminated either before or at the end of his probationary period. So, the court can only intervene in the termination of a probationer if there was malafide. But this traditional viewpoint has changed in some point. The State Distilleries Corporation versus Rupasinghe case. In this case, the court has taken some kind of progressive approach. In this case, Justice Fernando pointed out that the employer's right to dismiss a probationer is not absolute, unfettered or unreviewable, and the employer's subjective decision is liable to limited scrutiny and review. So, this decision has challenged the traditional viewpoint of the court and accepted that the probationer's right to challenge the unreasonable termination. However, still there is no certainty with regard to this matter because all these decisions are came from the judicial interpretation, and therefore we can see our court time to time change its viewpoint with regard to the dismissal or termination of provision. So then, I'm moving to the South African legal approach. Actually, the significant feature of the South African legal framework is it has given statutory security for the probationary employees under the Labour Relations Amendment Act.
If I may interrupt,
Section 186.
if I may interrupt, could you please go to your conclusions because you have run out of your time. So just explain about the findings.
Yeah, okay, sir. I want to highlight that in South African legal approach, they recognize the probationer's right under the statutory, under the Labour Relations Act, and most importantly, the guideline 8.2 of the Schedule 8 of the Act recognizes, provides a very clear and specific guidelines for dismissal of probation. Under that, you can see after probation, an employee should not dismiss for unsatisfactory performance unless the employee has given the employee appropriate evaluation, instruction, training or guidance. And with this finding, here I have summarized the findings of my comparative analysis. Under this comparative table, you can see in South Sri Lanka and South African legal framework. I'm not going to discuss this, but you can see the main drawback in Sri Lankan law is there is no legislative protection for probationers in Sri Lanka when compared with the South Africa. So
Okay, thank you very much. Yes. May I now open for very small number of questions because of the time limitations.
So I would like to ask from the researcher, drawing on from the case law jurisprudence in Sri Lanka, can you theorize a probable approach and direction that the Sri Lankan law has moved towards, and also what do you think, what reasons compel you to choose South Africa instead of some other common law countries such as the UK, because our lawyers are bit inclined to look at English law principles in this regard. And as the last point, I would like to also ascertain from you, do you see any progressive trends from the judicial interpretation in the towards the advancement of probationers' position in Sri Lanka, in the Sri Lankan legal landscape?
Thank you for your question, sir. Actually, as I mentioned, the major drawbacks in Sri Lankan law is there is no specific provision or specific regulation with regard to the probationary employment. As I discussed, sir, our decisions of our court have changed time to time. So the state distilleries case was in 1992, but after that, in several cases, again our court jumped into the past tradition, the traditional view. So even though the Rupasinghe case put forward some kind of progressive approach, we can't say that our court making the same position at all the time. That's why I am proposing a separate legal framework should be, a separate statutory intervention should be in this matter. And also with regard to the selecting South African jurisdictions, so I think I selected South Africa mainly because both Sri Lanka and South Africa governing under the Roman Dutch law influence, and that's the main reason. And also in South Africa they have separate legislative intervention for the probationary employee, security of the probationary employee. That's the reason I selected the South African jurisdiction, sir.
Any other questions? In fact, I also have the same concern regarding the South African approach, and you have compared Sri Lankan case law with South African legislation, so which is not really balancing. But what I would rather advise you to take the World Organization with regard to the labor and take out certain recommendations that they have implemented or rather brought in the international conventions as a clear model to propose certain reforms in Sri Lanka with regard to the probationers. That's my advice. If you can just have a look at the international organization also. So thank you very much.
Yeah, actually in my full paper I have analyzed some South African cases as well.
Thank you very much, Monica. Now I would like to go to the last presentation today in this technical session on private law. And the title of the abstract is Impact of COVID-19 to the National Economy of Sri Lanka, a comparative analysis with the United Kingdom on employees' rights. The authors are A. Samarakon, V.P. Lianage, and M.R. Premashanta. And A. Samarakon is LLB graduate of General Sir John Kotelawala Defence University and currently studies as a preliminary year student at the Sri Lanka Law College. Her research areas are commercial law, criminal law, and labor law. V.P. Lianage completed the LLB degree at General Sir John Kotelawala Defence University. She is a preliminary year student of the Sri Lanka Law College. Her research interests include environmental law, criminal law, and constitutional law. And Mark Premashanta completed his LLB degree from General Sir John Kotelawala Defence University in 2020 and currently studies as an intermediate year student at Sri Lanka Law College. His current research interests include criminal law and constitutional law as well as labor law. So from now I would like to open the opportunity to present on the impact of COVID-19 to the national economy of Sri Lanka, comparative analysis with the United Kingdom on employees' rights. So over to you. And here you may start now.
Honorable Chair, ladies and gentlemen, our research topic is the impact of COVID-19 to the national economy of Sri Lanka, a comparative analysis with the United Kingdom on employee rights. Impact of COVID-19 on labor rights and national economy has become a prominent issue at present. As a result of COVID-19, national economy of Sri Lanka was highly affected. This decreased the national growth. For example, the Colombo stock market was highly affected by this unforeseeable pandemic, which reduced the national growth of country. Due to this, the profit of companies were drastically reduced and many issues related to labor rights have occurred. The aims of this research is finding out whether there are sufficient laws to secure labor rights in unforeseeable situations. The research problem is whether the prevailing legal framework is adequate to address the issues arising out of unexpected situations, specifically COVID-19, while contributing to national economy. And the objective of this research includes identifying the impact of COVID-19 to national economy and identifying whether Sri Lankan labor laws are sufficient to address such issues, and to propose necessary amendments to existing legal regimes to fill the gaps. Here, the research methodology would be a combination of black letter and comparative research methodology with the United Kingdom. This employs a qualitative analysis of primary data and secondary data. Labor legislation forms basic part of the national growth of a country, which provides rules to business or industries to address issues that might arise relating to wages, EPF, ETF, payment of gratuity, and working conditions of laborers. The objective of labor legislation include improving industry relations between employers and employees, minimizing industrial dispute, assisting workers in getting fair wages, ensuring job security for workers, etc. At present, in low and middle income countries, labor law reforms can help to construct institutions within zones which incorporate social protection aggregates and can add to the formalization of employment, which is a significant advance in decreasing financial instability, implying the effect of the national growth. Next, I'm going to discuss the UK legal regime on rights of employees related to unforeseeable situations. UK has introduced coronavirus termination scheme, self-employment income support scheme, changes to the sick pay, etc. Apart from this, UK has passed the Coronavirus Act 2020 to grant emergency powers to the government to handle the pandemic. This allows the government to relax regulations in various sectors as a precaution to limit the spreading of the disease. Coronavirus termination scheme was introduced by the Coronavirus Act by 2020, which applies to all employers in UK. Moreover, the self-employed income support scheme was introduced to provide grants to self-employed individuals for 3 months. Another important development is changes made to sector sick pay in response to COVID-19. This is payable to employees who has been advised to self-isolate under the guidance of doctor. The emergency volunteering scheme is also another initiative of the UK government to safeguard rights of employees in COVID-19 situation. This allows employees to take emergency volunteer leave in 2 to 4 weeks, statutory unpaid leave in any period of 16 weeks. And employers who volunteer through an authorized authority will be compensated for loss of earnings during the period. So, analyzing the UK legal regime of rights of employees related to unforeseeable situations, specifically COVID-19 situation, it is clear that UK has immediately taken initiative in response to the pandemic to protect the rights of employees, at least to a considerable extent. Next, I will be discussing the Sri Lankan legal regime on rights of employees related to unforeseeable situations. Firstly, 1978 Constitution of Sri Lanka recognizes the fundamental rights of every citizen to freedom to engage by himself or in association with others in any lawful occupation, profession, trade, business or enterprise in Article 14(1)(g). Moreover, with regard to employee rights, Section 31E of the Industrial Dispute Act states that the Act shall not apply to workers in workplace which has less than 15 workmen. 1 month preceding the retrenchment of any workman or to workmen in businesses which is seasonal in character or to retrenchment of any workman who have been employed for less than 1 year for any industry, and according to Section 31F, employer holds the duty to give notice of retrenchment to the workman or the union before 1 month. But this section applies only to disciplinary retrenchment. On the other hand, the Termination of Employment of Workmen Act would be important to identify the methods of termination of employees in the workplace, including the rights of employees specifically with regard to COVID-19. According to the Act, non-disciplinary termination occurs with regard to closed down business and retrenchment. When analyzing the Sri Lankan context, it is important to identify the changes occurred in the stock market on 11th of May 2020 due to COVID-19. Sri Lanka experienced a halting of trading time after the lockdown of that day, according to the unleased market, due to the fear of foreign investors exit from the risky assets, which directly affected the national economy. Since both local and foreign investors are looking at leaving from risky assets due to the global pandemic, the end result would be the fall of the domestic economy, which eventually will affect the rights of workmen, which is connected to the listed companies of the Colombo Stock Exchange and as a whole to the economic growth of Sri Lanka. Moreover, it could be identified that 3 main labor issues have arisen due to the pandemic. This related to issues under terms and conditions of contract of employment, issues related to termination of employment, and issues with regard to new forms of employment. However, it should be noted that with regard to the present situation, these issues have not been adequately addressed in a way which balances the rights and interests of employers and employees of the state. But it is important to know that the proposal introduced in Sri Lanka in relation to the pandemic suggests that employees should not be terminated due to the pandemic. Employment should pending yet. It is important to note that even though a temporary proposal has been introduced in Sri Lanka due to the COVID-19 pandemic, it does not effectively address all the employee rights on this basis. It is essential to repeal the current domestic legal framework which protects the workman's rights with a view to the future to face such unexpected situations, and it should be recognized as legal lacuna that should be filed in undeniably. So, I would suggest the following recommendations to address the same issues. Firstly, an effective program should be introduced to make awareness among employees in industries by supporting greater social protection. Secondly, if legislation can be passed to protect rights of both employers and employees in unforeseeable situations, specifically with regard to vendors, and to secure retirement benefits of private sector. Thirdly, existing legal regime on industry law should be relaxed to include unforeseeable situations to protect rights of employers and employees. Online to address this issue, at least an online parliament could have been convened to pass a special labour legislation which is also practicable and effectively based on the concept that prevention is better than cure. The study reveals that the existing industrial laws are not sufficient to address the issues related to rights of employees in unforeseeable situations, including COVID-19 in a way which would contribute to national economic and national progress.
Thank you very much. So I would like to open the floor for questions.
Ms. Samarko, now your work has focused almost entirely and extensively on employee rights. And can you give us the comparative rights of employers in a brief manner, sir?
Excuse me, can you identify yourself because I can't see you?
Sorry, I'm online.
Okay, sorry. Can you tell your name, please?
HGS Poseidon.
Okay, right. Okay. Did you get the question correct?
Yes.
Okay.
It is because employer should give prominence to employee safety in unforeseeable situations, specifically during COVID-19 because of the rapid global spread of coronavirus. And unless a better workplace is created by the employer to employees, it would affect the productivity and profits of business, which will also ultimately affect employer. So employee rights should be given prominence, but we would suggest that the balance should be struck between employer and employee interest because it is the main objective of contract of employment.
Thank you.
Any other questions? Then I would like to thank for the presentation, and it is my duty now to summarize the presentations made. And first of all, we had NKK Mudarige and A. Idrisinha speaking on their abstract titles are From Home, the Legal Status of Sri Lanka. The presenter covered the area of contract of employment, default, workplace, home of work, under shop and office, and the work-related costs, industrial disputes, remuneration, types of employment, and temporary measures and permanent measures. Thereafter, we had HGS Rosario and HG Javida presenting on the abstract critique of available remedies for industrial disputes arising out of COVID-19, a comparative analysis. The presenter spoke on the rapid increase of industrial disputes, ADK, alternative dispute resolution system to be put in place. Possible alternatives: one, as enactment of ordinary legislations, and possible enactment of two, as enactment of legislations with Public Security Ordinance number 25 of 1947. And thereafter we had the presentation based on the title Abstract Employment Security of Probationary Workers in Sri Lanka, a comparative legal analysis done by Ruwantika Ariyaratna, where she spoke on the probationary worker, especially with regard to the definition and the termination of probationers, with regard to the comparison between Sri Lankan and the South African laws, and the suggestion to reform the Sri Lankan legal spectrum with regard to termination of probationers. Then lastly, we had the presentation of based on the authors of A.S. Samarakon, V.P. Vienage, and M.R. Premashanta for the title, or abstract title, Impact of COVID-19 to the National Economy of Sri Lanka, Comparative Analysis with the United Kingdom on Employees' Rights, talking about the import of labour legislations to national growth, UK legal regime, where she took up the Corona Act to 2020 in UK, and also presented certain reforms that the Sri Lankan legal regime can take effect of. Then also on the latest issues arose due to COVID-19 in Sri Lanka. So in conclusion, let me also thank first of all the markers in this session, Dr. W.D. Rodrigo, Dr. Sampaku Chiheva, and Dr. Aravinda Fernando for being here to mark the presenters, and this is the technical session 3 on contemporary challenges and the role of private law. Thank you very much, the organizers, for inviting me as well to be the technical session chair.
Ladies and gentlemen, now we have reached the end of the third technical session.